Well, the U.S. Tax Court has released recent opinions of importance to agriculture, involving everything from hobby losses to conservation easement donations. We want to get an update on the impact for farmers and ranchers. And man, to do that, Roger McEowen with the Washburn School of Law is here to break it all down for us. Roger, always a pleasure. So from my understanding, the first case involved a parent-child income-sharing arrangement for a ranch and rodeo activities. Give us a little insight into this case and what this is about.
Yeah, this is a case, Suzanne, good to be with you, that a mother in Oklahoma inherited a ranch from her family line and operated it with her daughter. The daughter paid the ranch expense and mom reported the income from the cattle sale. So the daughter had large expense deductions on her tax return with a small amount of income from her children's rodeo activities. So she had tremendously large losses, $500,000 worth of losses reported on the return. IRS pulled that return and determined that the daughter's Schedule F farm activity was rodeo and disallowed the losses as a hobby activity. But the court came in and said, now, wait a minute. The activity was ranching, and the IRS hadn't challenged that as a hobby, so the IRS lost the case and really blew the whole case.
So talk about the takeaway for this case. I mean, this is...
Yeah, and that's the key point. That mom and the daughter really lucked out on this one. They were really operating this as an informal partnership, and their allocation of income and expense was not right. And I see this all the time with these informal arrangements in agriculture. The warning here is the IRS, had they done this right, they could have had an absolute field day sorting this thing out properly. So the point is to be really careful with your income sharing arrangements for the farm or the ranch, because if you do it wrong and the IRS analyzes it correctly, that can lead to really big tax problems. And the mom and the daughter were really, really fortunate in this case.
Yeah, big win for them for sure. Another case involved an employer-provided housing. Talk about that case.
Well, this is another big issue in agriculture, especially when we get into harvest season and we have meals taken out to the field for workers. But the case here was not an ag case, so I'll bring the application back. The case involved an Air Force veteran that was working in Australia, and the company provided housing for him 11 miles away from where the company was located. He excluded the value of the housing from income. Now, you can do that, but several requirements have to be satisfied. The lodging has to be furnished for the convenience of the employer. It has to be furnished on the business premises. And the employee has to be required to accept the lodging as a condition of employment. And his lodging didn't meet the test, and he had to include that in income.
Talk about the lesson here for farmers, ranchers. I mean, going into this, what do they need to know? Obviously, they need to make sure everything is very, very specific.
Yep, and this can be a big fringe benefit, but it's absolutely critical to make sure the meals and lodging provided to your employees are on the business premises and they are for your convenience as the employer. And so you really need to make the case that it's necessary for the business that the employee live there and take their meals there. Maybe it's a grain drying operation. Maybe you've got livestock that have to be watched, or your sheep herders out in Wyoming. You want them on the premises. Now, the facts are going to be different in each situation, so get good tax advice. But if you do it properly, the value of employer-provided meals and lodging can be excluded from income.
Yeah, that's it. Get good tax advice. Roger McEowen, always a pleasure. Thank you so much with Washburn School of Law. Appreciate you being here as always.